So the Heller case is next, and we're going to spend a little bit of time with an introduction, and I want to point a few things out in the case. You're going to be reading the entire case, and you will be briefing the case. Again, this is a very long case. It's a lot of reading. It's very important that you push through. Don't take this lightly. Don't just skim over it. Take the time, invest the time, and read the case. So what's it about? Well, the majority of this opinion is about interpreting two stretches of text. That is, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So you'll see how many pages, page after page after page, goes in to explaining this. So this is where they're going to look at the text and they're going to interpret it. You're going to see all sorts of ways that they substantiate, and in fact, in this case, the opinion is written by Justice Scalia. They substantiate reasons for their conclusion of what this means. So essentially the question is this an individual right or is it a collective right? As one way to articulate one of the issues. So a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So I put that on top of this case so you could have one quick look at it. So what do you think it means? Does this mean that the right of the people to keep and bear arms is really about the militia? It's about maybe the Army, the Marines, or the state militias, or the National Guard. What is this about? I get to carry, let's say, a firearm or a sword, but only if I am in a militia, a well-regulated militia. Is that what you think? Or do you think that this is about an individual right to keep and bear arms? And that individual right to keep and bear arms will definitely help the government out insofar as government needs to call up a militia. So we'll see what the case says. Now, I've decided to make you brief the Supreme Court case because this is a constitutional law class and we're supposed to look at Supreme Court cases. If you wanted, it's not quite Cliff's Notes, but if you wanted some of these arguments well articulated, I actually think that the Intermediate Court, the District of Columbia, has essentially an appellate court right there, and it is very well written opinion. I think they're right. I think Heller is right. I am amazed at how much time and energy went into writing this. So that's one of the reasons why I want you to experience reading through the entire case. It's because it is so long. But also, I think it shows you one way to interpret the Constitution using things like philosophy of language, linguistics, the historical use of words. You'll see. And so see if you agree with it. So we're going to scroll down. Hopefully y'all are used to the scrolling. This is the syllabus. Once we get past the syllabus, we'll have the opinions. This lets you know Justice Scalia, he delivered the opinion. Chief Justice Roberts and Justices Kennedy, Thomas, and Alito joined. Justice Stevens, there's a dissenting opinion. And then Justice Souter, Ginsburg, and Breyer joined. And then Justice Breyer wrote another dissenting opinion in which Stevens, Souter, and Ginsburg joined. More information about who represented whom. And then we begin. So we consider whether a District of Columbia prohibition on the possession of usable handguns in the home violates the Second Amendment to the Constitution. So I'm going to read a little bit about this because it gives you the story, and the story is important. So the respondent here is Dick Heller. He is a D.C. Special Police Officer. He is authorized to carry a handgun while on duty at the Thurgood Marshall Judiciary Building, a federal building. So he's authorized. In fact, he has to carry one. He applied for a registration certificate for a handgun that he wished to keep at home, but the district refused. So then he filed a lawsuit in the Federal District Court for the District of Columbia, seeking, on Second Amendment grounds, to enjoin or to stop the city from enforcing the bar on the registration of handguns. Also, the licensing requirement, insofar as it prohibits the carrying of a firearm in the home without a license, and the trigger lock requirement insofar as it prohibits the use of a functional firearm within the home. So there's a police officer. He's a federal police officer. His job requires him to carry a firearm, and yet where he lives in his city, he's not allowed to have one in the home. And even if he had a long gun, the long gun can't be ready to fire. It has to be non-functioning. So he says, this has to infringe my right. So he files a lawsuit, and it goes all the way to the United States Supreme Court. So in this version of the case that I have, the footnotes are almost immediate, which I think is helpful because some of the footnotes are to the dissenting justices' opinions, and I think it's very helpful. That's why I chose this particular version of the opinion. So the great insert. So we turn first to the meaning of the Second Amendment. And that is what I want you to focus on. In fact, the focus of this opinion is almost entirely on the meaning. But what does the Second Amendment mean? So we will come back to our page 4 here. What does this mean? That's what the court is asking. A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. What does that mean? I never doubted what it meant since the first time I read it, but apparently there is much doubt. So we first turn to the meaning of the Second Amendment. So here it is again, a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. In interpreting this text, we are guided by the principle that the Constitution was written to be understood by the voters. Its words, its phrases were used in the normal and ordinary as distinguished from technical meaning. So this is from 1931. It is United States v. Sprague. That is from that opinion. So you're going to read this. I'm not going to read this part to you. I'm going to point out parts of it. So you will see page after page goes into discussing this. So just to set out the two sides, though, let's look at that. Here are the two sides of the argument. Petitioners and the dissenting justices believe that this right, or rather the Second Amendment, it protects only the right to possess and carry a firearm in connection with militia service. So it only protects the right to possess and carry a firearm in connection with militia service. Respondent, that is Mr. Heller, argues that it protects an individual right to possess a firearm unconnected with the service in a militia, and to use that arm for traditionally lawful purposes such as self-defense within the home. Now, you've read the Texas Constitution. It's much clearer. We wouldn't have to have this case because it mentions some of these things. So we look to grammar. The Second Amendment is divided. Straighten this up. It's divided into two parts. Its prefatory clause and its operative clause. Prefatory clause and its operative clause. Now, watch what Justice Scalia does. The amendment could be rephrased because a well-regulated militia is necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. And he's not just making this up. He's citing a treatise on government and constitutional law from 1867. He's also citing the amici curiae, which is a brief. And this is a brief of professors of linguistics in English. Professors, a group of professors of linguistics and English, they hired a lawyer to write them a brief, right? They're not a party in the case. They're sort of friends of the court. Now, this, I actually really would love to go through this line by line with you. I really get excited about this. I really do. But what I want to do is jump, for purposes of this overview, to the operative clause. Right of the people. The first salient feature of the operative clause is that it codifies a right of the people. Now, the word codification is important here because the argument being proffered is that this is a right of the people, and the Second Amendment restricts the government from infringing that right. The amendment doesn't give the right. It's a pre-existing right, a natural right. It is a right of the people. It exists, whether you like it or not. Maybe it's one of those inalienable rights. And the Second Amendment makes it abundantly clear that the federal government, at least at the beginning, the federal government cannot infringe that natural right. So the way they figure out what the right of the people means is they find other places where the phrase right of the people is used. So if the drafters use the phrase right of the people in other areas, it would help us to understand maybe what they meant if they're consistent about using it. So there's in the First Amendment, in the Fourth Amendment, search and seizure. The Ninth Amendment uses similar terminology, not exactly the same. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Not exactly the same phrase, but similar. All three of these instances, here's the claim, unambiguously refer to individual rights, not collective rights, or rights that may be exercised only through participation in some corporate body. That's going to be a huge deal. But this is interesting. He notes, Justice Stevens says, well, you can't assemble by yourself. And while that may be the case, that doesn't mean that the right only attaches once you've assembled. It's an individual right, not one conditioned on membership. And then look at this language here. This is why I wanted you to be able to see the footnotes immediately. And Justice Stevens is dead wrong to think that the right to petition is primarily collective in nature. And I think most people would agree with that. You're meaning I can't petition the government unless I have an assembly of people? Of course not. So this is just how this is going to go throughout this opinion. Then we have provisions of the Constitution. So that we, the people of the United States, Section 2 of Article 1, providing that the people will choose the members of the House. The 10th Amendment, providing that those powers not given to the federal government remain with the states or the people. Scrolling down, there's 6 other provisions of the Constitution that mention the people. The term, again, here is the argument, unambiguously refers to all members of the political community, not an unspecified subset. The people seems to have been a term of art employed in select parts of the Constitution. Its uses suggest that the people protected by the Fourth Amendment, by the First and Second Amendments, and to whom rights and powers are reserved in the Ninth and Tenth Amendments, refers to a class of persons who are part of a national community or who have otherwise developed sufficient connection with this country to be considered part of that community. Think about that. The protections, the Fourth Amendment, the First and Second, the powers reserved to them in the Ninth and Tenth, refers to the same sort of class of persons, people. So this is a Supreme Court case from 1990, Verdugo Urquidez. So he argues this contrasts markedly with the phrase the militia in the preparatory clause. There's much more to it. Just going to move on. The next thing that's happening in this opinion is they're trying to figure out what does keep and bear mean. So first of all, we have the right of the people. They said the right of the people is an individual right, at least insofar as we can tell from the rest of the Constitution, and there's some other arguments. Then they move to another stretch of text, and that is keep and bear arms. What does that mean? We move now from the holder of the right of the people to the substance of the right. So this is a right of the people. Great. What is that right? It's the right to keep and bear arms. So before they address keep and bear, they try to figure out what arms means. And now this is where I think the Intermediate Court of Appeals opinion is really good if you wanted to take a look at it. It's really well defined. It gives some great examples. I hesitate to make you read it, but I do strongly suggest that you do. It might actually help you understand what's going on here, but this is what I have chosen for you to read and to talk about. So they move from the right of the people, and then they try to figure out what does keep and bear arms mean, and so they are actually starting with the word arms. What is that? And they look to the dictionary. They look to a lot of other things too, lots of other laws, history, even to England. Then they turn to the phrases keep and bear arms. They're literally like, this is not a joke. They are trying to determine what does it mean to say keep arms and bear arms. And this is not a joke. They really are trying to define keep as it relates to arms. They really are trying to define bear as it relates to arms. And there is much written about it. So far, we're not done. We're just looking at the operative clause. At the time of the founding, this is a complete dictionary of the English language from 1796. At the time of the founding, as now, to bear meant to carry. And then this is interesting. Justice Scalia uses one of the dissenting judges or justices when she wrote an opinion sort of defining what wear, bear, and carry meant. He uses her own words sort of against her. Think about what he is doing. I think that's a pretty strong, I mean, say, hey, you're the one who said this and it's Supreme Court language. This is what it means. And so maybe we stick with what you said then. So there's much more you're going to read. I want to point out a few more things. Lots and lots of history. And then we move to the meaning of the operative clause together. So putting all of these textual elements together, we find that they guarantee the individual right to possess and carry weapons in case of confrontation. This meaning is strongly confirmed by the historical background of the Second Amendment. We look to this because it has always been widely understood that the Second Amendment, like the First and Fourth Amendments, codified a pre-existing right. It's a very powerful declaration. The very text of the Second Amendment implicitly recognizes the pre-existence of the right and declares only that it shall not be infringed. I used that language earlier, and I wanted to make sure I pointed it out to you. So this is huge. It's a codification or a putting it down into writing of a pre-existing right. Two more things. Move to the prefatory clause. What's a well-regulated militia? Now, I think, again, that the Court of Appeals opinion is helpful here as well. This is a little bit of a shorter argument, as you might see. I say shorter, but not necessarily that much shorter. What is a militia? A militia is not an army. It's not a standing army. When someone says, oh, this is the National Guard is the militia. Well, probably not. Maybe. Depends on how you interpret a few things. But I think what they meant when they wrote militia here is able-bodied, typically men, free men, who had access to firearms and whatever. They were ready and willing to be called up, but it's just sort of everyday Joes, as it were. And then they could be well-regulated. So the militia is a militia, then there's a well-regulated militia. And so this is what he goes into and talks about what is a well-regulated militia as opposed to a mere militia. So he deals with the adjective well-regulated. He argues that it implies nothing more than the imposition of proper discipline and training. He's got all sorts of things here to sort of prove up this position. That's all, though. It's well-regulated, implies nothing more than the imposition of proper discipline. And he spends a sentence, essentially, on it. We move to the security of a free state. This is key because state here doesn't mean one of the United States. one of the states in the Union. Security of a free state, they didn't mean a particular state. They meant a state like a free polity. So state in its more general sense. And that's key, because if it just means the security of a free Texas or a free Louisiana, although I still don't think that changes the meaning altogether, but this is important, because when you see the word state, if you're not really, your head's not in the game with what they may have been thinking back then, this is important. So keep in mind, at least Scalia's argument is that security of a free state meant security of a free polity, not security of each of the several states, as the dissent below argued. So there's actually very intelligent human beings sitting on the Supreme Court who think that this refers to the several states. Justice Scalia says, no, 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 no. It doesn't mean that. It never meant that. So then we come to the relationship. Does the preface fit with an operative clause that creates an individual right to keep and bear arms? He argues it fits perfectly. It fits perfectly. Let me highlight this. It fits perfectly once one knows the history that the founding generation knew and that we have described above. That history showed that the way tyrants had eliminated a militia consisting of all the able-bodied men was not by banning the militia, but simply by taking away the people's arms, enabling a select militia or standing army to suppress political opponents. This is what had occurred in England and prompted the codification of the right to have arms in the English Bill of Rights. Debate with respect to the right to keep and bear arms, as with other guarantees in the Bill of Rights, was not over whether it was desirable, all agreed that it was, but over whether it needed to be codified in the Constitution. We're not going to spend much time here, but see what he's saying? The debate wasn't, do we need to put, or do we need this right? Let me say it this way. The debate wasn't, do we need this right? Do we need to protect this right? The debate was, yeah, this right's pre-existing. The question was, do we need a federal Bill of Rights, or do we not have a federal Bill of Rights? The right existed to keep and bear arms already, at least Scalia argues. It's a pre-existing right. The debate was whether it needed to be codified in the Constitution. Some argued it didn't really need to be codified. Some said absolutely it needed to be codified. So here he lists some, this is actually a great reading list, frankly. Letters from the Federal Farmer 3, the Complete Anti-Federalist. We're reading some Federalist and some Anti-Federalist as well. So then, the prefatory clause does not suggest that preserving the militia was the only reason Americans valued the ancient right. His argument is they work together beautifully. Now, he's not just telling you what it is saying. He's bringing in history. He's bringing in his colleagues' opposition and dissent, and he's dealing with it rhetorically. And then he also brings back how this fits in with the rest of the Constitution. So I wanted to highlight footnote number 17 here. Article 1, Section 8, Clause 16 of the Constitution gives Congress the power to provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of the officers and the authority of training the militia according to the discipline prescribed by Congress. He writes, it could not be clearer that Congress's organizing power, unlike its governing power, can be invoked even for that part of a militia not employed in the service of the United States. And then he argues against his colleague, Justice Stevens. He resorts to using as evidence the Federalist and the Anti-Federalist essays. He then goes, so this is the next thing that's happening, and argues based on, look at all these states' constitutions, they had similar language, and this is what they mean and what their courts say. So he's used a linguistic argument based on history, based on what it must have meant here and there and where we got it. Now he's moving to the states, and he's arguing that the states have language, and this is what the states have always meant, And therefore, since those people were around, right, that's the kind of argument that he's making. So we have Pennsylvania, North Carolina, Georgia, Massachusetts, right? He's going through the states to build up his case. And then this is what I consider sort of the attack on Stevens section. It's Justice Stevens this, Justice Stevens that, Justice Stevens that. And then he moves, how was the Second Amendment interpreted immediately after its ratification? And so he's looking at commentary there. So he looks at the post-ratification commentary. Then he's going to move through to the pre-Civil War case law, interpreting this or speaking about things. And then finally, post-Civil War legislation. He uses all of these to prove up, and we're not done yet. We're done with my discussion and pointing out, but he uses all of this to prove up what these words mean. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Much ink is spilled. Mindful that the question is to the meaning, but the question vacillates between the two sides. Is this the right to possess and carry a firearm in connection with militia service only, or is it an individual right unconnected with service in the militia? That's sort of the two sides. So there's much ink spilt. I know it's a lot of reading. It's not very difficult reading. You know that this is the overarching question is, what does this mean? What does this mean? So every sentence in some way is going to help get at the meaning of this. Now, if you would like to, you're not required to, you can read the dissents as well. And the dissents, obviously, it's where Justice Stevens, for instance, is arguing his position, not from merely the footnotes of Justice Scalia's opinion, where he's arguing back and forth with Joinder, but he states his case. So if you are interested in that, I think it would be a good idea. Now, I will be requiring you to read in our Obergefell case the dissents as well as the opinion, because I do want to sort of have some expectations for you and to give you the responsibility of reading at least one Supreme Court case all the way through and the dissents. And I think that those dissents, however, are one of which is written by Scalia. I think the dissents are interesting and they're helpful no matter which side of the argument you come down on in showing that an appropriate tone can be had in disagreeing with your colleagues on the Supreme Court. I think it's a good example. And I also think that the Obergefell decision was decided wrongly. I don't necessarily mean that the result was wrong, but I would have argued a different way, and I would not have given such nuance to some of sort of the fundamental rights that we have had before. But you can agree with me or you can disagree with me. I want you to read it for yourself, though. But in this case, you don't have to read the dissents. You just have to read the majority opinion, and then you will be doing a case brief. So good luck with that, and I hope that you find this interesting. It certainly matters. If we were in an in-person class, I would actually have you all either raise your hand or just speak about what you thought at the beginning. Hey, is this sort of a collective right or individual right? And then after you've read Heller, to see if your mind was changed or not. And then you could evaluate the arguments of Justice Scalia and the majority and the two dissenting opinions that were sort of cross-joined. In this case, you're going to be looking at just the majority opinion. So good luck with that, and I hope you learned something very interesting.